If you're negotiating with your ex about who gets what in property settlement or where the kids are going to live and when, then you need to listen to this episode so you can get your BATNA and your WATNA sorted. In this episode, we're going to talk exactly what those terms mean, and don't worry, we're not going to use legal jargon, and how having these can give you more power in your negotiations with your ex. Welcome, Mum.
Hello, Laura. Hello, everyone.
So today's episode, we're going to be talking basically about negotiating, whether it's in mediation or in court, but predominantly it's a strategy, isn't it, Mum, that they taught you because you are a qualified mediator.
Yeah.
It's a strategy they taught you through mediation.
That's right. And it's used in mediations in all sorts of things. And I wouldn't be surprised if the United Nations uses it as well when they have mediations between countries. So it's very powerful.
Just a reminder that the discussion in this episode may include discussions of family violence and coercive control. Please call 1-800-RESPECT or Lifeline if any of this triggers you. Right. Okay, well, let's get to the jingle and let's get started.
Okay.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Okay, so Mum, what is a BATNA?
It's your best alternative to a negotiated agreement. So
right.
B for best, A for alternative, T is to a negotiated NA agreement.
Right. Okay. And then WATNA must be what?
It's your worst one. It's your worst alternative to a negotiated agreement. And of course, the alternative to working things out between you in a negotiation is court.
Right. So most people, when they go to mediation, they've got this list. You might have our mediation checklist, and it's got all these documents you need to provide. It's got all these, you need all your disclosure. You need all this information. And people are preparing that. But I guess they're not really preparing their BATNAs or WATNAs. And so it's actually something that I think a lot of people don't do. They just hope it's all going to go well without strategy. And so why do you learn about BATNAs, Mum, and why is it important for people to have them? How does it help them in their negotiations?
Yeah. Well, it helps them face reality. I think it is a mindset or a change in the way you think about things. So you may be holding on to an idea, and as a mediator, someone might be really stuck with, I have to have the television or whatever. And it's important sometimes to ask them, all right, so imagine today doesn't work out and you don't have a negotiated agreement. What is your alternative? Are you going to go to court? How much is that going to cost you? And you reality check them. What if you still don't get that in the settlement? I think it's more important probably than having lists of stuff. It's a way of thinking. Yeah.
So negotiations, whether it's mediation or letter writing or talking to your ex, it's not just about what you want. And I think if you and your ex go into your mediation or writing letters to each other and you're banging your heads together because you're saying, this is what I want, and they're saying, this is what I want, and you go to mediation and you don't have any other alternatives, it's obviously not going to work. It's going to be a disaster. And then if you go to court and you're still negotiating and you say, this is what I want, and they say, this is what I want, there's no alternatives, there's no negotiation properly, you're going to end up with a judge deciding for you, and it might not be what either of you wanted. So it is a hard thing. It is a hard thing to think about other alternatives, but it is definitely worthwhile as a way, like you said, Mum, to get over these big hurdles. And if countries do it in the United Nations, then we could do it too. Yeah. So I'm actually going to take you through some steps on how to create your own BATNA. We're going to give you some homework today. But before we do, Mum, have you got any examples of some real life stuff that's happened in mediation? Because you've done hundreds of mediations. Have you seen it where people have managed to negotiate because they've got a backup plan, or ones where people have walked in and they've got nothing?
Yeah, I have seen it. I think that a person who knows the law and knows how the court is likely to treat their case is in a much better position going into mediation than someone who is really just looking at what they want. So, and it might be that you come into court, and I've seen people come into the mediation, and they've got a case that backs up their story. And they're saying, but if I go to court, I'll get this. And we always call that their bright, shiny case alternative. What if something comes up and it doesn't play out like you think it does? So we should maybe have the MATMA, which is the middle alternative to negotiated outcome, where you don't get everything you want. And like you said, it's some person you don't know who's going to be making these decisions and you lose control. So, yeah, I had a lady who came in for a mediation. This was decades ago, but she wanted her property no matter what. She wanted this particular property and she had the money to pay her partner out. So that was all right. But we were left negotiating over a piece of antique furniture and she would not budge on that. And fair enough, it was sentimental. She didn't budge. They walked away. Well, that unit went up in value and she could no longer afford to pay him out. By the time they got to trial, even though they negotiated at the door of the court, she lost the unit as well as the piece of, I think she got the piece of furniture. We hear back sometime. So as so often that happens, Laura, where you've got to be realistic and you've got to be a little bit pessimistic. And then, to see what might be.
And look, I've talked before about how I've been avoidant. And if you're listening, you might be an avoidant yourself where you just don't want to deal with this and you're hoping that somehow it's just going to magically fix itself and everything's going to be great. And you've done all the things you have to do, all the disclosure documents, all the stuff, but you walk in there and you just don't know what's going to happen. You haven't thought too much about it and you're just hoping it's all going to end well. It doesn't work like that because it's you. It's literally you and your ex, and no one knows your ex better than you. That your lawyer's not going to have two ideas about what's going to leverage them to move a little bit closer to what you want. Because you know. So you have to put in the time to do these steps.
Well, when you've got countries negotiating, right? Let's go to the countries negotiating. There's a lot of emotion sometimes in those big things, but the people who go in to negotiate on behalf of their country know exactly what they're facing if they can't get a settlement. That's in their worst case scenario. They have a best case scenario. They hope that if they go to the international court, something else will be found. But they go in with a strategy and companies go in with a strategy. And it's a bit hard in a way to expect a person going through divorce and separation to go through it in that kind of professional way when there's still that emotion, like that poor lady with her antique piece of furniture. If it had been a commercial matter, the company would have gone, oh, who cares? You have that, we'll have this. So it is hard, guys, but it works. It works.
Get a pen,
yes.
Get a piece of paper. You can press pause if you want, so you can go and grab it. And again, this isn't legal advice. This is us just giving you some steps that you should take. General education. So go get a pen and come back to us. And I want you to, even if this is all you do, it's going to make a bigger difference than doing nothing. The things you need to do. So there's different things for property as opposed to children's, but let's talk about the property first.
Okay.
So first of all, step 1 for BATNA, for property, list all your assets and debts. That's it. Pretty easy.
Yeah.
That's your property pool, right?
Yeah. But put your estimates if you can't work out a property. A lot of people fail to be able to agree on something. So you work out what you think it's worth and maybe put an E in front of it. Just come to a number.
And if you're going to mediation, you've probably already had to do that anyway.
Yeah.
But these are for people who are negotiating, not at mediation as well. And Mum, you said make sure you list any post-separation contributions.
Absolutely. Yep. And anything that's been sold since separation by either of you, put that money back in. If it's been used on reasonable living expenses, put a little note there that it has. And don't forget the things that you've got. Because sometimes it happens often when people sell a house, they're working out how to divide up this money between them both. But they forget that the court looks at all of the assets, including the stuff that you've got in your house now. So don't forget that you've already got probably some super and you've got this stuff in the place and probably some money in the bank.
Okay. And we've got great episodes and our course shows you how to do a really solid property pool, but this is just a quick bang through. Number 2, identify what you need financially. So calculate what is your living expenses like and what kind of future needs have you got? What things are you going to need in the future? thinking about your housing, where you're going to live, if you're looking after the kids the most, like how are you going to pay for these things? So you really need to sit down and think about what is it you need financially to live.
But it's important to remember that you may not have the lifestyle that you had, okay? And it's important to remember that you may have to cut your lifestyle for a while. And don't forget too, when you're working out what you need to live, imagine if you go to court and get that, exactly what you need, but it's minus the $40,000, $50,000, $100,000 you've paid on legal fees. So yes, and also it's what you need and how soon you need it is also an important point.
Yeah. Okay. So then the next step is understand what the law might award you. So and this is where you see a lot of people trip up, isn't it, Mum?
Yeah.
Particularly if they're doing it themselves or they're letter writing to each other, but they've never seen a lawyer and they have no idea how the court would do it or what cases are similar to theirs.
They're listening to Tracy in the lunchroom or that bloke that their mate that went through it, and really every case is so different. So, so not knowing what the law is going to award you or not listening to what your lawyer says. If your lawyer says this is the amount, you should be able to trust that. If you know a bit about it yourself, if you've listened to podcasts or done our course and you're not sure or not sure they know, get a second opinion. But but don't ignore all the legal advice. I do remember one mediation I went to, whether I was for the wife, the husband was really unrealistic. But he came into mediation and he had 5 sheets of paper in his hand, like when we used to write letters. And he said, I've seen 5 different lawyers to get the right answer. So how do you know your lawyer's got the right answer?
So he went shopping for an answer
until he got
wanted.
the right answer that he saw. And we were doing this as a mediation in the court. Like some people will get court-based mediation. And the registrar was not backwards in coming forward and telling him that perhaps 4 lawyers were correct and maybe he should listen to them.
Oh, dear.
Yeah, so...
Okay. Yeah. So really you need to understand the law. You need to see a lawyer, listen to some episodes, figure out what are your contributions, what are your... They're not called future needs anymore, Mum. What are they called?
Current and future circumstances.
They've changed it, but current and future
Laura,
circumstances.
they never said future needs. We all just used to say it. So it never was a thing in the Act. It was called 75 two factors.
Okay. So, and then, of course, the Family Law Act. So you need to figure that out. Okay. And if you haven't done that, you can't really be negotiating well because you don't know. So then the next step 4 is consider what you'd get if you went to court. So you need to think about how much are your legal costs? How long is it going to take? You know, and Mum, how long does it take these days to get into court?
They're hoping it will be a year from when you file.
And that's for final trial?
Yes, for final trial.
But it's not?
Well, some registries it is, I think.
Okay.
But if you've got a 5-day trial, obviously it's harder to find 5 days together than if you've got a half-a-day trial or a 1-day trial. The court makes an assessment based on what you've got. So, yes. So that's, I think time is a factor you need to take into account. Would you rather have $1 today than $1.50 in a year to come and having spent on lawyers' fees to do so?
And look, you pointed out that lady who could buy that house and could keep it, but then by the time they went to court because she wouldn't give up on that antique furniture, she couldn't anymore. So there's a lot of issues with delays. And then that includes the emotional toll of dealing with this nonsense of upheaval and no certainty for a year.
I don't know how people do it for a whole year. And
it's horrific.
A lot of people sell the house, they've got the money in trust, and then they take a long time to get to court to get a final hearing. When you get your money, the market may have moved up and you may no longer be able to get back into that suburb or back into the housing market. So there's a lot of risk in not settling. So it's important for you to think about that, even if you might get more at a final hearing.
Right. So once you've come up with the property pool, you've identified what you need financially, you've understood what the law might award you, you've considered what you'd get if you went to court, which kind of would be your best.
Yes. Well, see, not everyone wins in court, right? But everyone who goes to court thinks they can win.
Right.
don't they?
So
Because
your
you wouldn't go to
BATNA
court.
probably would be the court outcome.
You hope. Yes.
You hope.
Yes.
Yes.
Because it's not guaranteed. So many things happen in the course of a court case. Someone might be terrible under cross-examination, or, a judge might be grumpy.
Yeah. Yeah. And then you really need step 5 is to build a realistic plan B.
Yeah.
So if you are going to end up in court, what are you going to do for that year? What's your plan? What are you going to be doing? How are you going to be affording it? Where are you going to be living? You really actually need to think about these things. What are the interim arrangements?
And another realistic thing, Laura, realistic thing is to ask yourself, if I put this offer to my ex, what would stop him or her from accepting it? So try and put yourself in the shoes of your ex and imagine how they feel with this offer. What is it that makes them tick? What is something that if you put it in the letter, that's going to be an explosion and that's never going to settle? And so make sure you're being honest with yourself, that you're not just putting things in that they can't accept.
Right. So it's something. So your BATNA is basically what?
It's a good negotiated outcome. Okay.
Okay.
That's what BATNA is. And a BATNA is what you would get in court. On a bright, shiny case day where everything goes your way and the judge gets it right in accordance with the law and the orders come out exactly how you want it. Now, the trouble with that is if that's your best case scenario and if you go to court and get it, it might be the other side's worst case scenario, what you get. And so they may trot off on appeal.
Right.
And it's not final anyway.
So you've got to put that in your plan as well,
You do,
I guess.
And that could take another 6 months or so. So I always felt when we have a spectacular win and the client is walking on air, I go, you may find.
Here comes the appeal.
Here comes the appeal, yeah.
Yeah. All right, so let's look at BATNA for children's agreements.
All right,
and you're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your questions. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today. All right, so let's look at BATNA for children's agreements arrangements, and then we're going to talk about what to do with them. Okay, so what do we do with these plans? So the BATNA for children's arrangements. Number 1, write out what's best for the children. So consider their schooling, their routines, their health needs, their emotional safety, anything that you think needs to be considered when it comes to the best interest of your kiddies.
Yes.
Then, step 2, outline a parenting plan that you think is in the best interest of the kids. So, including what time they spend with each parent, what happens on holidays, what happens on special events, decision making, and the best way to go through all of that, if you've got the time, which I hope if you're going to mediation or court, you really need to do this. Yeah. You can go and look at our 12 agreements episode, or you can go and do the actual with the whole module on it where we take you through all of this to consider, because there's a lot to consider. But really, step 2 of your BATNA for kids is outlining a parenting plan that you think's in their best interest.
Yes.
Step 3, think about what your ex's likely position is going to be. What are they asking for? Is it reasonable? What might they agree to under pressure?
And what would stop them from agreeing? What's their immovable post?
So you need to literally brainstorm this stuff. If you've got a manipulative, controlling ex, and we've talked about this in our Can You Go to Mediation with a Narcissist? We've also talked about it in our episode Soft Glove with an Iron... What is it again?
Iron hand in a velvet glove, or iron fist in a velvet glove.
We've done a mediation episode on that. But basically, sit down with your bestie, sit down with a family member and go, what kind of crazy things is my ex going to throw at me at mediation or in a letter? What can I prep for? How can I preempt what they're going to try and do? Is that right?
Yeah,
what position?
I think you take some of the shock out of it. if you think, when you're thinking, what is it that if I put it in, it's going to derail the agreement, then if you've got a manipulative and controlling ex, you brace yourself. What crazy thing could they put in that in order to destabilize me and derail the thing? So it just takes the sting out of it. If I predicted this, didn't we? We saw he was going to do this.
You always say sometimes it's a good idea to have a bingo sheet. Don't let it get that ended up in court, but a bingo sheet of, in mediation, my ex is going to say they never loved me anyway, or my ex is going to say I want 100% custody of the kids, or my ex is going to say I don't have any money for child support.
Yes, my business
could guess
has gone down.
Or they're going to bring up some fight you had in 2010. So just think about all the things they're going to do and have a little bingo sheet there for you. And because you're putting humor into it, you're not going to be shocked. Your brain's not going to be upset. The trauma's not going to be triggered. And then you can still negotiate with confidence in a mediation.
Yeah.
Right. Step 4, we're getting sidetracked because we're going to talk about that a bit later. Research what the court might do. So we've done that in the property one. We've got to do it again. So the courts are going to look at the best interests of the children.
That's right.
So do you know what the best interests of the children are?
Each parent, I guess, has an idea of what they think the best interests of the children are. However, I think the dialogue's really, over the last 17 years or so, the dialogue has become more about what's fair, what's 50-50 or 40-60, what's fair. And so the court pulled that back with the amendments last year. And now you need to be looking at what the best interests of the kids are. I used to think it was helpful to put a photo of the kids in front of you so that if you get hit with something from the other side, that's it. That's the last thing. You can remind yourself you're doing this for the benefit of the children. And children do thrive when they are in a situation where both parents roughly agree or have agreed. They don't do well in the litigation process. And even if they do talk to a family reporter, writer, and they probably have to talk to an independent children's lawyer, and you think that's it, they don't have to talk to anyone else, it's all good, it's really me. Think about how you are as a parent the days leading up to and the day after a court event, when you get a court letter, one of those 5 to 5 on Friday letters. You're not parenting at your best. And
unless you're a robot.
Yes.
Even no matter how hard you try, no matter how much meditating, how much chocolate you eat, how many self-care days you have, those days, I bet you any money that cortisol levels go off the charts.
Yes.
Is it cortisol is the bad stuff, right?
I think it is, yes.
Your inflammation markers will be off the charts. Just standing in a courtroom, shaking in your boots, no matter how well you present, you can't hide all of it. And it will affect your ability to function as a human, let alone as a parent. If your kid has a meltdown, your levels of patience will be tiny as opposed to, they're just having a meltdown, I'll calm them down and we'll go back to normal. You may snap. So there's all these things you've got to take into consideration. So whilst you're researching what the court might do, have a little think about what you might do. Again, the emotional toll, the delays, how is it going to affect your kid? Is your kid resilient enough to deal with or we still don't know when you're going to what day or on what holidays. Are they going to cope well with that, or are they going to bug out? And so you need to think about that.
Yep.
And then,
so I think that it's very subjective thinking about what's good for the children. And if you've been very hurt by your ex-partner, you may think that they would be better not seeing your ex-partner very often. And that may be right. It might be a very strong visceral response you've got to it. But if you're really not sure, and if you're both a distance apart, maybe get a family report. Family report will report on the children's development and how their dynamics are. And I mentioned it before about a family report. It's not too stressful on the children, but it does give you something to rely on for what may be in the best interests of the children. It's so hard.
You're not a fan of child-inclusive mediation though, are you, Mum?
Nope.
Yes. And that's because that's like a very light version of a family report. So you might as well just do the family report.
It's a waste. And you'll probably be ordered to do a family report anyway if it's unsuccessful. And the kids will have been kind of, yet again, they become very practiced at being interviewed, and they lose that spontaneity, children do. And then a family report writer may be deprived of the opportunity to actually see what's going on with the kids. So you work it out, Rosie, what you think is the best interest of the children. And it's very hard to negotiate on this because you feel like it's every extra day. It's usually that or whatever is bad for the children. If you really believe in your situation and the other person's sticking with 50-50 or whatever, you may have to go to court. But you still need to kind of do this test with yourself.
So, and that's the last step in the kids one. Create your BATNA parenting plan and include in that, what if you don't reach an agreement in the mediation or negotiations? What's your next best option? Is it applying for interim orders? Is it requesting for a child report, family report, or is it just going to another mediation?
Yeah, or just doing nothing.
Yeah, that's
and leaving the kids with no orders. That sometimes is a reasonable outcome. It just depends. It might be that the status quo that you've managed to nut out is not too bad for the kids. So you really do have to add that in. You can't do that with property. It's very rarely that property settlement is better leaving everything where it is because if it wasn't necessary to divide the property or just inequitable to divide the property up, the court won't hear it anyway. So if you've each got a reasonable amount, you shouldn't be anywhere near the courts.
Yeah. So again, Mum's not your lawyer, so get your own legal advice about what your situation is. Let's quickly look at what a WATNA is, and then we're going to look at how to use it and what to look out for when you're going into these things. So a WATNA mum, which you rightly pointed out, is the worst case outcome.
Yes.
So worst case.
Worst alternative to a negotiated outcome.
So the best way for people to find the WATNAs is look at other people's court outcomes. Go and read some cases. Check out your legal costs again. Think about the emotional cost and how the fear of a WATNA can sometimes lead to bad deals. So that's important to know. So I've heard some of our members where their ex is going for 100% custody of the kids, okay? And that is the WATNA. That's the worst outcome. So people then panic and they seem to start to work from that, as opposed to working from the reasonable place and the negotiating of where it would be reasonable to start from.
Yeah.
But the fear of losing your children can sometimes affect the way that you're on the back foot, and you need to readjust your brain to put yourself back on the front foot.
And how hard is that when you've come out of it? If you've come out of a relationship where there's been coercive control, and it is a person who genuinely does not have the kids' best interests at heart, but want to take the children off you because that's control as well, then you're probably not strong enough in that moment to be able to resist or to be able to insist on what's right for the children. And that's why I say to be very careful about being pushed into mediation too quickly. You need some distance. You need to get some other points of view.
And that gets us to our red flags of when you're being pushed into settling without knowing your alternatives. So that's it. One of the tactics is they try and push you into mediation as soon as possible before you're emotionally and legally ready. Yeah?
Absolutely. I've seen it a couple of days after separation because the person who's leaving has been planning it for months, but it takes the other party by complete surprise. And then and by the way, we've got mediation on Thursday. It's so cruel and unnecessary.
Another strategy that's used by exes, like we just talked about, is the fear strategy. Well, if you don't do this, you're going to get this happen to you. And so instead of going in on equal power footing in a negotiation, there's one of them is like really still controlling the story, still controlling the elements. Please call 1-800-RESPECT or Lifeline if any of this triggers you. So, Mum, are there any other examples of red flags? Because we hear a lot of people, they go into these negotiations and it's usually someone who has come out of an abusive relationship and they are kind of pushed, they say they felt pressured into signing an agreement.
Yeah.
And so are there any other tactics that you see happening where people are tricked into it?
Yeah. I see people, they know they have to go to mediation. And if a mediation's been set up, even though they haven't had an opportunity to even choose the mediator, they feel like they have to go or they'll be seen to be being a bad parent. Another red flag is if the mediation is to take place perhaps at your ex's lawyer's office I would never agree to that. It's all just building on that perception of a power imbalance. And that would include to your lawyer as well. If you guys troop in, have to wait in reception, then go to a room, you're clearly guests in that space.
The one I've seen is where they feel like they want to be seen doing the right thing. They don't want to be seen as the troublemaker. And so when the mediator or whoever is saying, no, you need to do this, like people pleasers, they go, oh, okay, well, I have to do it because that person's coming from a place of authority. I don't know what I'm talking about, especially people with really low self-esteem. And if they've been in that dynamic their whole marriage, then the dynamic just continues into the divorce.
Going. Yep.
And, that their ex's manipulation tactics may be people are going to think you're greedy. People are going to think you're dragging this out longer than you need to. Just sign and agree now.
Another classic is, you're just like my other ex. Don't do to me what they did to me, that sort of thing. So you'll see a red flag is where they are talking about themselves and they're talking about how many nights. How many nights is the flag? Because that tells me it's heading towards child support agency decisions.
Yes.
Yeah. And if they're talking about fair and 50-50, I've hated that phrase from the minute it was born, because we're not arguing over a pot of money or an apple. This is kids,
Yeah.
And if you have 50 and they have 50, no one's thinking about the kids because they've got none left, obviously. So you need to, if they're not being child focused, if they can't give a good reason why the children should be going to their place as often as they've got in their mind, then maybe that is a red flag. Maybe that's a red flag that no matter what you offer, they won't accept it. However, the law is a lot clearer now, I think. You can rely on that to comfort yourself and perhaps push back to their lawyer and your ex about that they're being unrealistic about what's due and slowing it down. Don't feel you've got to walk out of that mediation with an agreement. If there's a lot of pressure coming on you from maybe your lawyer or the mediator, look, they may be right. They may be right. And maybe they'd say you'd be mad not to accept this. They may be right. But if you feel pressured and you aren't sure, tell them you'd like to think about it overnight. Okay? Now, the risks of that, of course, is that the offer from the other side might disappear. But if it was a good offer on the mediation day, I think it's still a good offer the next day. And I'd be then thinking about it. If you agree, then write them a letter agreeing to it and try and work it out from there.
I think there's one other dynamic that we need to talk about in this being pushed into settling and not knowing your alternatives. And that's the ones where they control all the money.
Yes.
And you may be desperate for money. You may be desperately trying to figure out how the heck are you going to keep going. If this mediation doesn't settle today, you're going to be eating baked beans for the next 6 weeks. So what you really need to understand in those situations is the court has ways of getting around that. So if your ex is saying that you're not going to get a drop of money out of me until you sign this agreement, but you can get spousal support, you can get spousal maintenance. And that's where they pay you, if you're eligible, and you can listen to our episode on that, until you've got your property settlement or even a little bit after. So you can flip the table.
That's
you can flip
right.
the table.
Yep.
So don't think for a minute that you have to agree to something because you're desperate for money at that time. The court has set up mechanisms to ensure that doesn't happen. People just don't use it.
Yeah. And also you could have an interim property settlement. If there's money somewhere, you might agree that each of you can take a certain amount. That takes the heat off you, that takes the pressure off you, which is another alternative. Yeah.
So there's some things you just need to be aware of when you're in there. But Mum, how does using a BATNA empower you in negotiations? Like, how does it give you confidence?
Using the BATNA or the WATNA?
Yeah.
Using
the BATNA or the WATNA.
Yeah.
How does it help you?
I think it puts a framework around what you could probably settle with. You might get offered your best case scenario, your best alternative to negotiate an outcome, your court answer, they may offer you that, or you may come to that, and hooray, you're in that realm and you know it is your best option. But on the other hand, if they come back, if your negotiations get stalled somewhere around your worst possible outcome, it's still a possible outcome. And you should think about that because it will cost you legal fees to get there. And so I think it sets a kind of cap and collar for where you should be negotiating in. And always remember, you'll be given letters about what your legal fees are likely to be. Take that into account so you can get a kind of realistic outcome, I think. Yeah.
And when you're negotiating in that mediation room or you're in another room and they're shuttling across from one to the other, you don't have time to sit down and ask yourself those 5 questions for both the property or kids. You don't have time to do the research to find out how long it's going to take, how much it's going to cost, what's going to happen next, what do you like? Like, you don't have brain space or power to do it in a mediation. So if you've got it all written there and then the mediator comes in and gives you an offer, you can look at all your paperwork, all the work that you've done, all the brain work you've done today, and it may assist you in making a better choice or a decision where you will feel better. Because I know a lot of people, when they're given an offer, they don't know if it's good. They don't know if they should accept it. And so and then if you've got an ex who you're sus on or they're manipulative, controlling, or the last thing you want to do is trust them that they're giving you the best option.
Yeah. And I've had people come to mediations and my allergy to Excel spreadsheets and things, but they've got a spreadsheet. And if the other side came back with an offer, they would just plug that number in and it would work out their percentage. It would work out how much extra cash they had a week, how much they had to borrow if they wanted to buy a car. Like, it was all in there.
Wow.
And that meant they were able to know the real impact of what the offer is. You were talking about a red flag before, and we forgot a really big one.
Oh.
Disclosure. Unless you know what the other side's got, or if they've been funny about disclosure, my view is you shouldn't be doing property settlement until you've got enough disclosure for you to be able to work out if you're getting a reasonable offer or not.
Valid.
So that's a very big red flag. I don't think you need full disclosure all the time. You need enough disclosure so that you know what's a good outcome. That's when it comes to property matters.
Yeah, I think you might be right. We've got some great episodes on disclosure, delays in disclosure, what to do if they don't give you a disclosure. So you can go listen to those episodes. Mum, that spreadsheet you're talking about, again, that brings me out in hives, but how good would it be to have that?
Yes.
And if you're not that kind of person, go and see a financial planner. If you can find one, if you're lucky, or an accountant, and say, can you help me figure out what I need to live on? And all the questions that we asked. And then, can you help me create a spreadsheet so I can just plug stuff in and see if it's going to work for me? Or ask them to give you a range and say, okay, well, you can comfortably live on this amount of money or this. So get them to really, if you're not a money person, go and talk to a financial planner and accountant. Get them in their big Excel spreadsheet brains to have a look at it for you and to give you a guidance.
And if you're looking at buying a property, a lot of banks now have a free budget calculator available, and they also have things like, how much can I borrow? What will my repayments be? Like you said, Laura, it's so true. You don't have time to be thinking about that in a mediation. Plus, if you're paying a mediator by the hour and you're paying your lawyer by the hour and the other person's paying their lawyer by the hour and probably a barrister, like, it's a very expensive thinking time, isn't it? So it pays to do the work.
I thought the lawyer would do the thinking for me. I thought, we'll just go in and the lawyer will have done and do the thinking for me. But then they'd come in and ask the question and they'd look at me. And I go, oh. Yes. And I realised how integral you are to the mediation. It is, they're just there to provide support and legal
and options.
Advice.
And I think they would tell you your WATNA and your BATNA. But you need to know, I guess, what it means to you. And at the end of the day, that you are doing all the work. It's you that has to make the decision. And it must have been a shock. And I'm very sorry, Laura, that you weren't prepared for that, because it's the whole thing is about you. They can't agree on your behalf.
I had no clue.
Oh, darling.
I know.
I remember your barrister got you to ring me. It's time to ring your mother. He said.
Yes.
So,
but just thinking about the fear and the worry and the stress and the whole lot of it was horrendous. And I know if you're listening to this, you're going through it. And that's why if I could go back in a time machine and do this 5 questions for property, list all the assets and debts for your property pool. Then step 2, identify what you need financially to continue living. Step 3, understand what the law might give you. Step 4, consider what you get if you went to court. And then step 5, build a realistic plan B
Yes.
And then for kids, write out what the best interest of the kids are for number 1. Step 2, outline your parenting plan that you think is in the best interest of the kids. Step 3, think about what your ex's position's likely going to be and how you might be able to negotiate them to yours. 4, research what the court might do in relation to your case. And then step 5, create your BATNA parenting plan and have it with you on the day. And if you do that extra homework, I really do think it'll be a shorter day. You'll know if your ex is because if your ex doesn't do this and they're not sure what they're legally entitled to, they don't know what the law is, they haven't seen cases, all of that sort of stuff, and they're completely saying, no, I'm keeping all my super and keeping all the house and you're not getting anything. That's obviously for you, okay, well, I should probably walk away. This is a waste of the day.
Well, though the other thing is, if you've done your research carefully, and I've had to do this many times in a mediation, the other side is being completely unrealistic. I write down a case or I do the workings on a piece of paper to send in for them to look at it. Oh. Your offer means this, and here's this case. Your offer is way below what we would have otherwise got. So if you've done your homework, you can say, no, but that just gives me 20% of the property or whatever. You're the one with the knowledge then.
You can educate them.
That's right. Yeah. And it arms you up for, and if you sound like you know what you're doing and they don't know what they're doing, like.
Remember that lady that wrote to us? It was about a year ago now. And she said that she went into the mediation and she basically was like, no, the law says this, so I'm entitled to this much. And this is, and her ex asked her if she'd done a law degree or if she was studying family law. And she said, no, I've just been listening to the podcast and I did the course.
What was so,
and she got everything she wanted. He just gave up and went, oh, okay, she knows what she's talking about.
He was gobsmacked. And I think for her was a little bit nice for him to be in the position of not having a clue.
Being in the passenger seat.
That's right.
Once. Yeah. But yes, we were very proud of her and I love those emails. If you want to send us some more victory stories, I love them. But yeah, so it's empowering.
Yep.
Once you get your head around it, it's empowering. And that's really all it is to it, because if you go in there like a scared little mouse, you're going to choose your decision like a scared little mouse. But if you go in there like a lion and you've got all your information and they hear it in, which is like a lion's roar, oh, she knows what she's talking about, or they know what they're talking about, your outcome's going to be different, your position's going to be different, the tone of the conversation will be different, and it's protecting your future. Yeah. It's your future.
And when you walk out there, if their offer has been below your WATNA, the worst case you'd get in court, at least you can walk away knowing what the next step is, and you won't feel quite so deflated as if you've hung everything on this mediation and it hasn't gone to plan. A lot of people called it a failed mediation, and I feel sorry for people. It's not really failed, is it? It was.
No.
It's one option you've got.
It's the next step.
It's the next step. That's right.
If you want to listen to that episode, we've done an episode on what happens if your mediation fails and what you can do about it. And we've got an episode. I'll put that in the show notes as well. I'll put the questions in the show notes too. I might do a PDF. I'll see if I get the time.
Yes.
But thank you, Mum, for telling us about the world of BATNAs and WATNAs. And if you are listening to this, even if you haven't got mediation coming up yet, it's time to sit down and think about these. It sounds like a lot, but even if you just have a little go at it.
Yeah.
If you don't know, just put NA, but just have a little go at it and really just think, what's your BATNA, what's your WATNA for kids and property? And you may find that it changes the way you negotiate.
And once you've done it once, it will probably stay the same between the mediation and any trial, so that you can still negotiate within that framework after the mediation.
That's so true. And I'm going to tell you what you can embroider on a cushion. Actually, Mum.
You do it, darling. What?
Really? Okay, and this is learnt the hard way. Walk in prepared, not just hopeful, because hoping for the best and being prepared for the best are two different things. So, yeah.
I like that.
So I want you all to be prepared.
Yes, I think that's right. Yeah. Yes. Yeah. And it'll be a pleasant surprise if it all works out that way. But you know what your ex is like. But you can use these situations, Laura, to get information as well. You walk out and at least you know what they're going to be saying if they go to court.
least you know what their BATNA is.
Yes.
All right. Well,
Okay.
thank you, Mum, for your time today, and good luck to anybody who's doing that. And if you are thinking about doing this, it is definitely a good step to take. All right. Thanks, Mum, and we'll see you next week.
Bye, Laura. Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording,